Representative Chu spoke earlier in her opening remarks about how Arizona's immigration law institutionalizes racial profiling. And she also said that people are already being detained because they forgot their driver's license at home. Could you add some clarity to that statement for this panel, please?
Well, I'm not familiar with the incident, perhaps, that Congresswoman Chu was talking about. The concerns that I have expressed are with regard to the whole question of preemption and whether the statute gets into areas that are more properly handled by the federal government, and what the impact of the law will be on law enforcement and its interaction, its relationship with certain communities in Arizona.
Then perhaps if I just state into the record that the Arizona law isn't enacted, doesn't go into effect until 90 days after its passage and signature by the governor, then we could agree that any action that would be taking place on Arizona's immigration law would not take place until 90 days after it's signed by the governor, and the balance of any activity might have been inspired by the press or public dialogue, but nothing on the authority of the legislation could possibly be taking place at this point. Would we agree?
Again, I'm not familiar with the fact situation that she mentioned.
Wouldn't that generally be the standard, though, if it were a federal law or a state statute, that until it's enacted, it can't have an effect legally, and so her remarks that she has made could not be relevant to the law's enactment itself?
Again, I don't know whether some police officer, thinking that the law is going to be taking effect, has acted in a way that's inappropriate. I just don't know anything about the fact situation that she has described.
Then let's try this down the path of the Constitution preemption, which you mentioned. As I understand Arizona law, and I could probably list a couple of minor exceptions, it mirrors federal immigration law. The question and the charge that seemed to come from the President was that the Department of Justice was going to be looking into Arizona's immigration law and presumably to evaluate its constitutionality, which you've referenced, and whether it would violate any federal statute under that preemption clause. Could you today point to anything in the Constitution that would prevent Arizona from passing and enforcing immigration law, provided it didn't go beyond the bounds of federal immigration law, within the idea of mirroring that federal immigration law? And is there anything in the Constitution that you could point to that would define Arizona's immigration law as unconstitutional or potentially unconstitutional?
Well, the regulation of our borders and the immigration that occurs by crossing our borders is something that is inherently something, I believe, for the national government to take responsibility for. As I indicated, I understand the frustration that people feel in Arizona. We have not done, I think, enough as a nation to deal with a very real problem that people in the southwest border have to deal with, but is really more than them. It really is a national problem. I think that is why the President has said that a comprehensive look at this issue, dealing with the causes of illegal migration, as well as what we deal with those people who are here without documentation, is a way in which we can hopefully solve this problem.
But General Holder, we've digressed into policy, and as far as specificity with regard to the Constitution or current federal statute, and you've already gone in and investigated this, I presume, at the direction of the President, so you should know today whether there is a constitutional point that can be made or a federal statutory point that can be made. And I will suggest that I have looked at this, and I've asked our attorneys to look at this, and we have not found a constitutional argument that that would indicate that Arizona has violated the federal Constitution, nor have we found a way that Arizona has gone beyond the bounds of federal immigration statute. And I'd point out also that in the Constitution, there's nothing there that defines immigration law as the exclusive province of the federal government. Only two places: protection from invasion, and then Article 1, Section 8, that says to establish an uniform rule of naturalization. The balance of that is implicit, and case law supports local law enforcement enforcing federal immigration law. So how would you respond to that?
Well, our review is still underway. We've not made a determination yet whether or not federal law preempts the Arizona statute. That is something that we are examining, and I was saying that was one of the two bases upon which we might take some legal action. But we're not at that stage yet. We're not at that point where we have made the determination that, in fact, it contravenes federal law.
Well, and just in response briefly to that inconclusive answer, I'd point out that there have been a significant amount of resources that have been invested in looking at the Arizona immigration law. It appears to follow a pattern of political actions of your office, and the ACORN investigation couldn't seem to get started with one single individual or one single investment of dollars, which has this country entirely tied up in knots, and it threatens the underpinnings for our Constitution, our legitimate elections. The threat to our legitimate elections, that's the one thing that would tear this country down, is if we lost our confidence in the electoral process. Yet we can't investigate ACORN, but we can investigate Arizona, and we still can't find out what might have brought your attention to that, as you haven't pointed out anything in the Constitution or federal statute or case law that would direct anyone to look into the Arizona law. So I'd be happy to conclude my statement with that and yield back the balance of my time.
Thank you. The gentleman's time has expired.
I just want to make one point very clear. The determinations that we make as to what statutes we look at, what cases we investigate, are done in a political way. I'm quite proud of the time that I've spent in this Department of Justice. I consider myself a career guy. I've served very proudly under both Democratic and Republican attorneys general. I understand the traditions of this department. I will not allow this Department of Justice to be politicized. People may not agree with the decisions that I make, but I want the American people to know that, right or wrong, the decisions that I make are based on the facts and on the law and have no basis in politics. That's not what this Justice Department is about. That's not what this Attorney General is about.
Gentleman from Georgia, Mr. Johnson, is recognized for 5 minutes for his questioning.
Thank you, Madam Chairwoman. General Holder, there have been a number of myths that have been perpetrated by politicians seeking to inject politics into the political process. And one of these myths that has once again reared its ugly head has been the notion that the Obama administration and you, as the Attorney General, placed the U.S. at risk by prosecuting terrorists in federal court, including the Christmas Day bombers and the 9/11 defendants, and now the Christmas Day underwear bomber and the gentleman who was recently arrested for leaving a car packed with explosives in Times Square. And now, prior to this issue becoming a political football, the Bush administration had tried numerous terrorist suspects in the federal courts, including the shoe bomber, Richard Reed, whose case is strikingly similar to the underwear bomber's case, and also Zacharias Moussaoui, the so-called 20th 9/11 hijacker. Is it true that, according to the Bush administration numbers itself, that there have been over 300 anti-terrorism cases that were prosecuted in civilian courts after 9/11?
Yeah, that is the number that I think is accurate, and I think that we learn from that number and from what we have been able to do in the 15, 16 months or so that this administration has been in existence, that our federal criminal courts can handle these matters. History shows that. The facts demonstrate that. The concern I have is that to the extent that people want to take away from us the ability to bring cases in the federal courts, you take away from us an extremely valuable tool. You actually weaken this country. You weaken our ability to fight this war against those who would do this nation harm. We have to be able to use our military power. We need to use our military commissions. We need to use our diplomatic power, our economic strength, as well as the federal criminal justice system if we are going to be really effective and ultimately win this war. We should not have this tool taken away from us.
Well, now tell me, during the Bush administration, when these 300 or so cases, anti-terrorism cases, were making their way through federal court to final disposition, the success rate in those prosecutions was phenomenal, was it not?
Yeah, I don't have the exact number, but the numbers in the very, very high 90% rate, very high 90s percentage rate.
Now, if you could, I've been having trouble with this. If you could tell me what has actually changed from the time that these 300 Bush administration cases were prosecuted in the civilian courts to the current time where we say that the civilian courts are inadequate, ill-equipped, and incompetent and unable to do what it has already established a track record of doing. What has changed now other than the assent of the current party in power to that position?
Well, I've often asked myself that same question as I look at people who hold themselves out as experts, pundits, on television, and who I think were notably silent when